The Office of Special Prosecutor, they say they see it all. Like an eagle, they have eyes everywhere, and they can see that we are heading for doom as far as corruption in this country is concerned. However, they have a problem. Their wings are being clipped, and they have a difficulty stopping the corruption. They will, however, continue. Question: the special prosecutor, a partner or an enemy of the state? As there are jubilations within certain circles and government associates over the problems that the special prosecutor appears to face, is the special prosecutor fair in the manner it suspects a ganging up, potentially, of judges against it in the execution of its mandate? Today, don't change your dial. Keep it right here, and you will enjoy it. We're back to Torrentco, a company that was formed how many months, and then it seeks to take a very critical state asset, the Tema Oil Refinery. CSOs in the oil industry gave a prompt in the same similar fashion they did with Ejapa, in the same similar fashion they did with that company that appears to have taken your money away but didn't give you electricity, PDS. Now, the Attorney General steps in, and the Special Prosecutor also steps in. About 6 months after these CSOs, Imani, ASEP, began to make the noise, the Attorney General says it has found out, indeed, that the company was incorporated on a holiday, the 1st of January 2023. But the Registrar General does not work on holidays. A lot of things smell exactly what Imani said: smoke and mirror. The company does not have the capacity. It appears to have only some 500,000 Ghana cedis, seeking to take over an asset for which assessment professionals say requires between 300 to 500 million United States dollars. Some others actually say require 1 billion United States dollars to bring Tor to what it ought to be. Question continues: how did this company come by the 22 million that it intends to take the assets for? Lithium, our new gold. And we're signing agreements already. People, including the former Chief Justice, Sophia Kufu, say the lithium lease is not different from previous colonial type deals. The questions being raised about this, are they justified? I'm Samson Ladianyanini. This is Newsfile. It's your most authoritative, and we mean it when we say that, news analysis platform. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, as always, we put Ghana first. We join in the studio by Professor Kofi Abochi, Dean, UPSA Law School; Inus Ofuseni, lawyer, former MP, Tamale Central, and former Minister, Lands and Natural Resources, Roads and Highways as well. Joining us by Zoom, will be Dr. John Osai Kwapong, Political Scientist, Democracy and Development Fellow, CDD, Ghana. And subsequently, on the other issues concerning our mineral resource and the AG's verdict that says the Torrenco deal clearly should not be able to go on. Well, the OSP started its investigations, then stopped the deal. Then the AG also stepped in and also has issued a report. On that issue, Bright Simmons, Honorary Vice President Imani Africa, will join us. Professor Bochi will still be in the studio with us, and Inusa Fuseni as well will continue that discussion with us. So, as you know, the Office of Special Prosecutor, led by the second Special Prosecutor, I say second, not to mean there's a first and there's a second right in that office. The first was Martin Amidu. The second, and continuing, is Kisi Ejabing, called a press conference and had a lot to say. Let's listen to excerpts.
That a careful examination of these outcomes portends a disturbing spectre that the fight against corruption is being hampered to the disbenefit of us all. And I do not say these things lightly. 4 instances will suffice. In one case, the OSP applied to the High Court for a confirmation of a freezing order in respect of a deceased person's estate. The judge refused to confirm the order by, in effect, holding that the OSP had come too late since the person of interest had died, and that his death had extinguished the inquiry commenced after the occurrence of death. We publicly commented on this outcome, and the danger of this outcome is obvious, members of the press. It is to the effect that a person may, in his lifetime, acquire property through corruption, and then upon his demise, happily pass on the corruptly acquired property to his estate, and by so doing, extinguish all scrutiny as to the propriety or otherwise of the acquisition of the property, because his corrupt activities were not discovered during his lifetime. In the second instance, the OSP had declared as wanted a person is believed to be a fugitive from justice. The person, through his lawyer, proceeded to the Human Rights Court on an ex parte application, and the judge, without even an inquiry as to why the OSP believed him to be a fugitive from justice, issued an injunction that the OSP should not arrest the person for a period of 10 days. Members of the press, this is dangerous. It encourages criminal suspects to go before the courts to seek injunction orders against law enforcement agencies from apprehending them. The judge did not advert his mind to the well-founded proposition that no one has the right not to be arrested, and he accorded the suspect a right not to be arrested. In the third instance, the OSP applied to the High Court for a confirmation of a seizure order and a freezing order in respect of a person who had just resigned from a ministerial position and had reported that large cash sums in foreign denominations had been stolen from her residence. In addition, the OSP subsequently discovered additional large cash sums in foreign denominations and cedis still stashed in her residence. The judge hastily dismissed the OSP's application and ordered a return of the seized amounts and the defreezing of her property. And he proceeded to lash out at the OSP for not doing a thorough investigation, without the slightest consideration that the seizure and freezing orders are designed by law to facilitate investigation into the affairs of suspects, and not the other way around, of requiring thorough investigations before the OSP can seize or freeze. The judge also completely ignored the fact that in almost every jurisdiction, including Ghana, it is extremely unusual and highly suspicious for a public officer to have such large cash sums stashed in their homes, and that the circumstances of the case dictated pause and reflection and the granting of the OSP adequate time to carry out its investigation. In our estimation, the judge was only interested in the return of the money to the person of interest and nothing more. Then he proceeded to erect non-existent legal barriers to prevent the OSP from investigating the matter. I'll revisit this case. Members of the press, in the fourth instance, the OSP had issued an investigation report in respect of the grant of a customs advance ruling by the Customs Division of Ghana Revenue Authority. The report opined that there was an institutionalized culture of light-hearted unconcern regarding impropriety of action at the Customs Division of Ghana Revenue Authority, which indicated a high propensity to engender corruption and corruption-related activities. Consequently, the special prosecutor directed the opening of a wider investigation in respect of the affairs of the Customs Division. Further, in pursuance of the office's mandate of taking steps to prevent corruption, the special prosecutor directed remedial action by Ghana Revenue Authority. The authority has instituted processes on the basis of the special prosecutor's directive, which has saved the nation substantial revenue. Then comes the problem. The affected customs officials proceeded to the High Court to challenge the work of the OSP. The judge accused the OSP of constituting itself into a court and a commission of inquiry by making findings. In doing so, the judge conveniently shut his eyes to an express statutory provision that the OSP has the mandate to publish detected acts of corruption, and that was exactly what the OSP had done in the report. I wish it had ended there, but worse. The judge then proceeded to prohibit the OSP from further investigating the affected persons. Members of the press, the judge fell into the grievous fault of what he accused the OSP of by outlandishly going beyond his jurisdiction with a purported clothing of the affected persons with immunity from investigation and hence immunity from prosecution. Members of the press, the duty and mandate of the courts is to apply and enforce the laws of the Republic, and not to grant persons immunity from criminal investigations and prosecution. A court cannot injunct the OSP from investigating or prosecuting any person. The decision to investigate and prosecute lies with the investigation and prosecution authorities, such as the OSP, and the OSP has at all material times carried out its power to investigate with candor and professionalism, being minded of the rights of suspects under its investigation. Members of the press, just as it is essential that anyone accused of a crime should have free access to the courts so that he may be duly acquitted if found not guilty of the offense with which he or she is charged, it is also of the utmost importance that the judiciary should not interfere with investigation and prosecution authorities in respect of matters which are within their statutory powers. It will be gravely inimical to public policy, the fight against corruption, and the administration of justice if the court stepped into this arena to decide who should be investigated, who should be prosecuted, and who should not. That is not the function of adjudication. The danger of this startling decision is again quite obvious. A judge has in the process granted two persons immunity from investigation.
That's the special prosecutor, Kisi Ejabing. So let me begin with Professor Kofi Abochi on what his thoughts are on the OSP and its mode of what it does. To start with, the OSP acknowledges that it has adopted what is a novel policy. And that policy, he says, is a policy of transparency. He says, in pursuance of transparency, we've adopted the policy that the office would issue a media release after every major judicial pronouncement or decision by informing the public on our judges' opinions in cases involving the OSP and stating the position of the office on the opinion in question as to whether it progresses the fight against corruption or otherwise. And people find problems with this. It says very senior lawyers have called him, and many compare him with the Attorney General and other prosecutors and say, you're supposed to be quiet and private and not the manner in which you are going about it.
No, I totally disagree. I strongly support what the OSP is doing. The OSP is an office which is involved in public interest litigation. I think it's important for us to understand that public interest litigation is not just another regular litigation. It is involved in the defense of the public interest. And when you're involved in the defense of the public interest, you ought to give feedback to the persons who are interested in the litigation involved or in the prosecution involved. The OSP, therefore, occupies an office which not only is novel, but an office which was called into being by the public, so to speak. This is a matter that dominated political conversation for many years. I do not see and understand what the reason is that after having been established, the OSP should operate in private. Mind you, we have to bear this in mind, that the OSP is interested in public facilitation of its work. And so if an office is interested in the public facilitation of its work, that office invariably would have to engage that public. It is when the OSP speaks to the public that the public can be aware of the extent to which the OSP's work is progressing, what the difficulties and challenges are, and if the public thinks that there are any circumstances of complementing the OSP's work, the public may, so to speak, come out and engage. So I think the OSP is doing exactly what they're supposed to do. Justice is not, it shouldn't be a private business. You know, lawyers have traditionally said this, that look, let's keep some of these things quiet. The legal actors who are supposed to be quiet are known. Jurors and judges themselves, they speak through the bench. The people who are supposed to be quiet are there. Indeed, lawyers who are involved in particular cases. And I've heard lawyers on radio, and I think these days the media funds that, but it's quite unprofessional. And that I totally disagree with lawyers who do that. In other words, lawyers who are involved in cases in court, coming out of court and then literally continuing the litigation on radio or on TV, you know, and basically arguing against each other publicly. That I think is a bit unprofessional. But that is not what the OSP is doing. What the OSP is doing is to give public feedback on specific developments on cases involving matters before him. So I do not have any difficulty at all with the fact that he's giving updates or periodic updates of happenings in court.
Martin Amidu was accused of speaking too much and doing little. He's facing same accusation, but his is quite different at one level, that his commentary has tended to concern critique of decisions that have gone against him. The law that sets up the OSP says he should update us quarterly of the cases he's doing, the status and outcomes as well. The law says he should make a publication of detected acts that it is investigating, detected acts of corruption. The law says he should do public education, engage the media, and so on and so forth. That is not the same as taking decisions of the court and running an appeal.
Well, essentially, you've actually repeated what the statute says. Essentially, my understanding, and if I listen to him, my understanding of what he's trying to do is to get the public to come along with his challenges and difficulties. I can understand part of the concerns that some lawyers may be raising, and the concerns may perhaps be the seeming direct critique of particular responses of the courts and particular courts. You know, the specific isolation of particular judges and particular courts in the circumstances of some of the challenges that he's facing. I think that the OSP is an evolving institution, and I think we need to understand that. I think Mr. Kisieja Ben has very little template, if any at all. Perhaps the one left by Mr. Martin Amidu. Beyond that, he doesn't have much of a template. And in this context, perhaps he doesn't even have a template at all. So we can understand some excesses which may be unintended, but fundamentally, if you look at what he is doing, he is trying to keep us abreast with happenings and events in the court. Perhaps some may say that he should begin going beyond the judges and the courts by actually keeping the public also abreast with specific developments of his investigations. You know, things that he may have found, things that he's having trouble finding, where he expects the public to come in, facilitations that he would expect the state to give him, for example. I mean, some will argue that the office of the OSP is perhaps one of the most difficult offices anybody can occupy in public service in Ghana. And the reason for that is that it is an office that requires the level of facilitation which ordinarily doesn't obtain in our criminal justice system. The OSP is supposed to be a forensically led office, fundamentally speaking. And forensics, as we all know, forensic investigation in Ghana is still very much rudimentary. You are investigating offenses that are essentially consensual in character, offenses in which parties are collaborators and cooperative in terms of their behaviors. And so these kinds of offenses are quintessentially difficult to investigate. And the reason they are is because the persons involved, nobody's going to speak to you. I mean, if parties have collaborated and are happy to be involved in a corrupt act, nobody's going to be reporting them. And if you're speaking to them, they're not going to turn against each other. You will have to have independent sources of information to challenge and contradict people's positions and to get them to come clean. Typically in Ghana, the criminal investigation regime is still very much rudimentary. And as rudimentary as it is, the OSP is now going beyond the regular crimes, which are even less difficult to prosecute because they are normally not consensual. But corruption being fundamentally consensual, you will have to have an office that has that level of technical expertise and competence, and he's building things from the scratch. I think we need to give him a flag, and as I said, these may perhaps explain some of the things that some people may consider excesses in his feedback, but he doesn't have much of a template. In the circumstances, he's giving us feedback, and I think overall, the picture is the OSP is coming against headwinds. How does he overcome those headwinds? And in this context, I'm just going to say that the office faces three key difficulties. Now, the first difficulty is the one of mandate. The second difficulty is the difficulty of perception. And the third difficulty is a systemic difficulty. If you take the mandate difficulty, that's what I just spoke on briefly. That difficulty that says that you come to court, you prosecute cases, and you're able to establish things on the basis of convincing facts, and you're able to do so beyond all reasonable doubts. All the defense has to do is to raise one doubt. Now, we say these things, and it is nice, some will say, it is sexy in our criminal jurisprudence, but the reality is it's very difficult when you're dealing with prosecutions because the persons involved, political exposed persons, and persons who are involved in corrupt acts, these are persons who have means. They are persons who can afford lawyers. So if they do pay for the best of legal services, and you are an OSP who has to convince the court beyond reasonable doubt, and then they have the best of lawyers, they are going to be able to raise one doubt or the other. That creates frustrations for an OSP who's trying to do his work. But beyond that, you have Section 38 of the law, which says the OSP has the authority and the power to actually embark on freezing orders. Now, the law is clear, and I think I understand that as part of his frustrations. If you listen to his tape that he played, you can tell that he's...
So do me this favor, you hold on with that. We are going to the substance of the examples that he raises that frustrates the office. We'll get to those 4 specific examples, without which there's actually nothing for us to discuss. So, Honorable News Officer, it does appear that when you guys were making the OSP law, because the OSP is not the Attorney General, you decided that whilst the Attorney General can enter, say, a plea bargain without explaining to anybody, can just show up in the court any day and say, this case, we are not interested, don't continue anymore. But the OSP, because he's sort of, I don't know how else to put it, you decided that if he must enter a plea bargain and say, we don't want to continue a particular case, he must give explanations, he must explain,
Yes.
give reasons for it.
Yes.
You intended to check the OSP so that he doesn't abuse his power. In the same time, by doing that, he's going to give the public information. Then you required of the OSP in section 3. Yes, section 3, subsection 3.
Yeah.
You said the office shall, on a half-yearly basis, earlier I said quarterly, it's half-yearly basis, publish the following information in at least 2 daily newspapers or national circulation and on the website of the office. List of corruption cases investigated and prosecuted by the office, and the number of acquittals, convictions, and cases pending in respect of the cases prosecuted under paragraph A, and the value of proceeds recovered. Then you didn't stop there. You made an LI for the SP. And in the LI, in section 31, regulation 31, you say prevention of corruption. The things he's supposed to do: undertake analysis of risk of corruption. So they are actually capable in one of what you have provided to actually identify individuals who are not qualified to be appointed into public office and to advise the appointer not to appoint them. Then you said also that they should do anti-corruption assessment of legislation, among other things. Then you said they should do education and information of the public. And then they should be publicizing detected acts of corruption. Publicizing detected acts of corruption. You didn't say the OSP should be holding media press conferences and critiquing judgments or issuing press releases after every case, critiquing a judgment and suggesting that there is a certain gang up by the judiciary against it.
Yeah, Samson, that's true. We didn't say that, and we had reason not to say that because judges are supposed to be independent in the dispensation of justice. And so when they do, there are several layers that you can employ. We lawyers will say that we believe that there is wisdom in one man's head, and that if you suspect that that one man is not exercising reasonable and rational judgment, you go to the Court of Appeal. And so you have 3 judges. We believe that the number of judges there definitely, shows that there is the likelihood of justice being done in the matter. And that if the 3 judges do not, in your view, exercise reasonable judgment in your matter, you escalate it to the Supreme Court. And there you are not having 3, you're having 5, you're having 7, you're having 9, you're having 11. And so we believe there's wisdom in numbers. Because the court structure is layered, we believe that if you try in the court of first instance and you fail, you have opportunity to go up and to go up and to go. That's why we didn't provide that. But I agree with Prof. entirely. I have tremendous sympathy for the OSP. It was a difficult legislation. It was difficult because the first challenge we anticipated actually when we passed the law was that someone would carry us to court and say that we had done an unconstitutional act. But you see, why didn't anybody go to court? Because there's consensus by the whole country that we have tackled the canker of corruption. There are only 2 things that are essential in defeating corruption: disclosures and transparency. So, yes, the special prosecutor used unconventional means to vent his frustrations, his lamentations, the obstacles that are being put on his way. He says it's novel. It's true, and indeed it's novel. It's not been aided because he's a lawyer. But you must understand, and Professor Bucci knows him very well, that he was a diligent academic, very hard-working lawyer. That he's important in the office And now his competence is being called into question. He's fighting to protect his own reputation and integrity. The office itself has great difficulty. I was the first person to criticize his appointment. Because I know what corruption can do. Corruption can be deadly. Corruption can be destructive, not only to the economy, but to the individual. Several anti-corruption fighters have been killed. Judges, journalists have borne the highest brunt. Corrupt people, killed them with impunity. The Malta case is still pending. So when he was appointed, I thought he had a very young family. And that family itself was now vulnerable. He himself was vulnerable. I didn't anticipate and think that a political party that had made it an issue in which Ghanaians bought into will work to frustrate the operationalization of the office. I didn't think that would be his problem. But now that is what is happening. See, we forget one thing. We look at what OSP is doing as if it's the normal criminal prosecutions or private cases that are being conducted in court. No. This public interest prosecution. And all of us are interested. The consequences of just prosecution and conviction are die for the convicted persons. They will be barred from office for almost forever. That they will be shamed. The shame will continue to their families. That they will lose all that they have got through illegal activities. So the consequences are dire. Now you have and Prof is perfectly right. We have been lawyers, we practice in the courts. These people are heavily resourced. It is not only that they can afford the best of lawyers, it is that they can also corrupt the courts. I can say that because I'm a politician. You might not say that because you are dean. Yes, they can also corrupt the courts. And we know that under the committee chaired by Honorable Mohamed Mumuni on corruption in the judiciary, the verdict was quite clear. There's some level of corruption in the judiciary. Anas Armiya Anas expose also confirms corruption in the judiciary. The former Chief Justice Anim Yeboah, during his vetting, said he could accept a goat from a friend, provided a friend did not have a case before him. Corruption in the judiciary. These people have leverage. Anything can happen in court. Yes, I've read the Constitution. The prophets here. In the whole Constitution of the Republic of Ghana, there is no provision barring an investigation into the conduct of a president if he's engaged in corrupt activities. There's only a provision barring prosecution while in office, but no provision barring investigation. So how can the court, by extension, grant an order prohibiting the continuing investigation into a matter?
So first I was saying, let's look at his policy, which he calls a novel policy of being transparent and commenting, or as it were, making releases particular to rulings or judgments.
Yes.
We'll come to those issues one by one.
Yes.
You say the office itself is novel.
Yes.
And if they are embarking on this novel transparency, journey, it's also okay.
It's okay. It's okay.
They are lawyers. They are the lawyers speaking for the GBA who say, I won't do what the OSP is doing. If I go to court and I don't win, I will focus on the appeals till I have exhausted everything. I won't be commenting publicly. And that's what the training of lawyers is. You shouldn't do that. The GBA's spokesperson says the special prosecutor should take the example of Godfrey Dame. When Opuni's trial, for example, where there was supposed to be a retrial, there was an order by one judge that the case should be started all over again. The Attorney General was not happy. He said he didn't come to the public organizing a press conference. He went to the court and got the court to change the decision. That's what the OSP should be doing, not talking in the public and criticizing judgments.
So talking in public, is it mutually exclusive of going to court? Is it mutually exclusive? Are they suggesting that you can do both?
Many have said prosecutors,
It might be unethical.
are known to be reserved and hardly will comment on matters that they are dealing with in court.
But this is a special prosecutor. Not so.
Special.
Yes. We didn't say prosecutor, we said special prosecutor. And so, and we took steps in the law. Give him operational independence. Okay. So he doesn't need a fiat from the Attorney General to organize a press conference of the nature that he did. Okay.
No, they're only saying you should take a cue from the Attorney General. And
well, in corruption, you don't fight corruption in darkness. You fight corruption throwing light on what you believe are obstacles to your fight against corruption.
The court is public. The court is not in darkness.
Well, the decision, he's criticized the decision of the court. And he can go up. He can continue to go up. Okay? But he needs to carry the public along.
All right. Hold on briefly for me. Dr. John Osai-Kwapong, thank you very much for having you. And he's a man who never misses the opportunity to talk about the Afrobarometer. I heard when you began to talk about investigations about issues with the judiciary, one place you didn't mention was Afrobarometer. Professor Osai-Kwapong, thank you very much for joining us. In fact, the Constitution has an injunction in Article 35, Clause 8, that the state shall take steps to eradicate corrupt practices and the abuse of power. The OSP must do this in the courtroom and stop organizing press conferences and criticizing decisions. Don't you agree from where you sit as CSO?
Well, good morning, Samson, and good morning to your other panelists. So I partly agree with the OSP, but I also partly disagree in some other areas. If you think about the issue of corruption and the fact that I think that there are times where you need to court public support in your fight against corruption, then I can see the virtue of his regular updates as required by the law. But also I can see the virtue of expressing frustration that he may feel on the job, right? Because I think that sometimes we tend to treat corruption as a purely legal fight, right? We subject it all the time to a legal test. And not that I have a problem going to the courts or dealing with the law, no. But I think the nature of corruption is such that you also sometimes need to use political tools to fight it. And some of those political tools involve courting public support, expressing your frustration to the public, so that the public may then find ways to put pressure or at least to draw the attention of some of these key political actors to, let's say, take the fight against corruption more seriously than perhaps they would ordinarily do. So in using some of those strategies, as a public administrator, he's doing the art part of it. It can't always be the science of public administration. So on that note, I agree with him using some of those tactics, right? If you look at the reaction that he's getting, you can see that the public's reaction is one of, this fight against corruption is much tougher than anyone can imagine, that is going to take a long time, etc., etc. So you sensitize the public to how difficult this fight against corruption is. The part where I disagree with the special prosecutor is, going into the specifics of, particular rulings and his disagreements with that, but also couching in a language that seems to suggest that there is some sort of concerted effort on the part of the judiciary to make his work difficult. That I think is very worrying. And it's also very worrying because the judiciary is not enjoying the best of public perception at this moment. You mentioned Afrobarometer, so I have to throw in Afrobarometer once again. But if you look at the question of trust in our courts of law and the perception in our courts of law based on the Afrobarometer data, the courts are not enjoying the best of public perceptions. And you need, and again, the level of trust is also at an all-time low. So when you combine all of these things, where you need to get citizens to find ways to repose or regain their confidence and trust in this very important institution, then it becomes even more worrying when the special prosecutor comes out and gives this press conference and say the kinds of things that may reinforce some of the suspicions or the mistrust that citizens are already having, in the court. And it is not every time that you would expect to, quote unquote, win a case in a court of law. For me, win or lose, so long as the institution followed all the right procedures and dealt with the case in a fair and impartial manner, then we must respect the outcome, because that is the only way I believe you can strengthen trust and faith in institutions, right? The real test of how much I trust an institution is not when things go my way. It is when things don't go my way and I'm able to still embrace the decision of that institution is how you build confidence and trust. And for me, that is the worrying part for me, with regard
your friends in the studio are lawyers, and lawyers of such standing,
yes,
that they disagree with what you are saying, because they say the special prosecutor is special. It's not just a mere prosecutor. In fact, the special prosecutor is not just a prosecutor. The things the special prosecutor does, your other prosecutors don't do. The Attorney General does not do the things the special prosecutor will do. The special prosecutor can, on its own, scan around the country and say, look, Samson is not fit to hold a public office. He should not be appointed if it is contemplated. Attorney General doesn't have that function. The Attorney General, again, the argument is, may not or should not be here to criticize the courts, because the Attorney General sits in the Judicial Council somewhat as part of the government. Again, the Attorney General is, quote, the unofficial leader of the bar. So he cannot do certain things. The Attorney Generals that we know, attorneys general that we have known, hardly prosecute their own, as in members of the government. Special prosecutor was set up to do exactly that, because they cannot do it. The attorneys general cannot do that. So there's a difference.
Yes. So Samson, I agree that there are key differences between the Attorney General and the Special Prosecutor, and there's something by design and the law that makes him, quote unquote, more special than an ordinary prosecutor or even the Attorney General. So I don't have qualms with that. But for me, I worry about the kinds of public conduct, right? Whether it's words, attitudes that may undermine the institutions that underpin our democracy. That is my worry, right? Which is why I don't have there's a way of expressing one's frustration with an institution without creating dissatisfaction or seeming to impugn on the character and integrity of the institution. Particularly because we are also at a time where, and it's not just the courts of law, we are also at a time where our institutions are enjoying the low levels of trust and high perceptions of corruption that we have seen so far in the conduct of the Afrobarometer. And yes, I'm not saying that these institutions are blameless. I'm sure that sometimes some of their own actions or inactions is what feeds the sentiment that citizens, express about them. So
Okay.
I don't absolve them of any I don't give them a clean pass. But I'm also saying that I worry that the Office of the Special Prosecutor would be part of this growing chorus that further reinforces this fight that I'm trying to
If the special prosecutor has evidence to suspect so, should it not be the one to lead that chorus?
Fair enough. If he really has evidence that some way somehow the courts or particular courts or particular judges are ganged up against him and making his work very difficult, that is fine. But again, Samson, I just feel or I just worry that in that role that I just disagree that he should be making the kinds of comments publicly that undermines an institution that is already battling public perception and trying to regain the lost trust and increasing perception.
So to be specific, precise, the special prosecutor said many lawyers, senior lawyers, have inundated him with calls, and they say that if he continued to issue those statements after rulings, the judges will gang up against him. I'll read that portion. I'll look for it and read it. Either he said that they told him that they will or they may gang up against him. But he gives you the 4 examples. So we can now move into that area. From where you said, you may start the analysis before we get to the lawyers in the studio.
Sure.
From what he finds, from the first, dealing with Sir John's will, which disclosed that he had willed property that belongs to the state to his family, which we will not have discovered perhaps until and unless he had passed. And the will became a matter for probating, what we call probate. The will has to be taken to court for a court to give power for the will, the things in the will to be distributed among those who have been named. And then the discovery comes out. He says, the court says, you came to court too late. Since the man is dead, the doors are shut. The special prosecutor says, I take strong exception to this one, and I think the public must know that this does not bode well for the prevention of corruption, and it doesn't help his work. He says, are you saying, and he uses that example, that the governor of the central bank uses money in the consolidated fund to do certain things? Because he's dead, we cannot take that money back? Is that what the court is saying? He disagrees with that. He shouldn't be saying that publicly.
So, but Samson, what does the law say? And I'm not a lawyer, but what does the law say? From the example that you're giving, if that is the law and the interpretation that a giving judge is giving to that case and saying, well, he's dead and therefore per my understanding and interpretation of the law, there isn't anything that can be done. If you disagree with the judge on that, at that level, I'm sure our court system, allows for you to appeal to, another level in the judiciary setup.
In fact, he has appealed. They have appealed to the Court of Appeal.
Okay, so Samson, is he saying that it's his expectation that every case he takes to the court that he is going to win, or that his interpretation of the law should be what carries his interpretation of the law should win every time? I don't think that is a realistic expectation. I mean, like I said, I'm not a lawyer, but I've followed judicial proceedings enough to know that, even sometimes lawyers themselves and judges themselves do not even agree on the interpretation of.
Tell me what you feel about that one. That should it be the law that you steal public assets or funds because you are dead? We shouldn't take it back.
No, that shouldn't be the law. But Samson, if that is the law that is currently on the books, and we find it problematic, which I do, right? Because if I steal public funds and I die, I can bequeath it to my family, to my children, things like that. So then you don't want my family to become beneficiaries of my stealing of public funds. But what does the law currently say? And if the law is what is getting in the way of preventing, this stealing to be bequeathed to someone's, offspring, children, family, then we have to do something about the law.
Okay.
Or if there is room to give the law a different interpretation, then that is what has to be done. But I don't think it's a realistic expectation that you would win every single case you take to the court.
Okay, so the next other case we can use, the next other case he speaks about, he says he's very worried that he's investigating Charles Bisu.
Yes.
Someone who has had difficulties in government and actually has been let go. And during the investigation, the man says, look, I don't want to be investigated because I have reasons why you shouldn't investigate me and you should not be prosecuting me. That is if you are done with the investigation. Mm-hmm. So he goes to the court. Mm-hmm. On the blind side of the special prosecutor, he goes alone, which is allowed by law, ex parte application, and tells the Human Rights Court that issue an injunction against the investigator, not to investigate me, not to arrest me, not to touch me, for 10 days. And the court issues that. He says that clearly doesn't help the fight against corruption. The next time you are going to have a terrorist, suspected terrorist, a murderer, all sorts of people seek refuge in the courts, and we are all doomed. What do you say?
But you see something, this is where I go back to something that the president once said, which in principle I agree with him. He says, not until you find yourself on the wrong side of the law, you would not have full appreciation for due process. These are things that we have worked into the system as part of due process. Yes, are there times where people may abuse that due process? Sure. But, the law doesn't stop one from going to the court to seek certain refuge, right? It doesn't necessarily make it right, but the law permits it. The process allows it. It can be frustrating. My mom was once involved in a land litigation that lasted 19 years, right? Eventually she emerged victorious. But can you imagine going through that for 19 years? But again, it was the use of all of the people she was fighting or who were fighting back would turn to the judiciary and use all of these rules, processes in place that allows for those things. In
that particular process, I can share an opinion with you. Sure. In that particular process, before now, it's all been devil's advocacy I'm playing. Now, in that particular process, from what I have known the process to be, it is a clear abuse of the process that leads to a one land matter stretching 19 years if it is sitting in one court.
Right.
In this same court, I have done a land matter in less than 1 year. So the question is, who do you blame? Do you blame the system? Today, the Chief Justice has started a process. If you have a case, for example, that is sitting there and you are not attending to it and it's idle, the next time you show up in court, the court by itself has struck out that case because you are not serious.
And yes, and all of those things, if we want to improve the efficiency in the administration of justice, should be done. But when you say that, a day would come when, a murderer or a terrorist may walk into the court to seek refuge. Well, in as bad as it may look like someone who has committed a terrorist act will still go to the court and demand certain things, we still give people who are accused of various crimes, even murder, certain rights. And that's why I said when the president says, not until you're in trouble, you don't tend to sort of fully appreciate the difficulty.
The OSP says,
yes,
you and I, when we are arrested, restricted, or detained on suspicion of one crime or the other, the Constitution trumps. The Constitution in Article 14 gives us the right to be liable to bail within 48 hours from the law enforcement body. If they don't grant us bail, then they will take us to court within 48 hours, within which we'll be giving bail. So it doesn't make sense, and it smacks of something very retrogressive in a corruption matter to say, don't touch the person, don't arrest him. When in fact, if the OSP arrested him, he will be entitled to bail within 48 hours anyway.
Right. I mean, something, and you see, this is, this is the complexity of any governance system, right? Okay. Where you have different parts of the governance system that some way, somehow, ultimately, you have to reconcile to be able to take a particular course of action, which is, for example, fighting corruption. But my point is that in as much as I believe in the fight against corruption, the persons that you accuse or suspect of these things also do have, certain rights. And so you can't just say that because I am charged with fighting corruption and therefore it should deny the other person whatever rights that they are also guaranteed under due process, right? You have to find a way of reconciling.
Yeah, so the question of the OSP is, what is the other rights of the other person that's been denied in these cases? The last example that you may share your view on what you think the OSP is saying is this one. He says, by the law, once I have a reasonable suspicion that you are committed or you are doing something which has to do with corruption, I should be able to come to the court and ask the court to freeze your accounts.
Sure.
And I should be able to seize your money. Now, he says, a judge says, no, in this matter, in the Cecilia Dapa case, you came late in respect of the seizure, the time that you must come for the seizure. He disagrees anyway, but he says the judge says, you have not done investigations. So you must have done investigations before you come and ask me to grant you the seizure or confirm the seizure for you. The special prosecutor says he wants all of us to know that this is wrong and this will not help because he is investigating. That is when he must seize or he must freeze your account. And the court must help it to hold the account until the period that the court says, if he doesn't bring you before the court to be charged, then he must release everything to you. So to expect that I should have done investigations before I issue a freezing order and come to you to confirm the freezing is retrogressive. It doesn't progress the fight against corruption. What do you say? Once again, he shouldn't be speaking about that.
Oh no! I mean, again, Samson, he can speak about that, but he's having a different interpretation, or he's having a disagreement with how a judge is also interpreting the rules of that particular process. Do you see what I'm saying? Again, Samson, for me, my worry is, yes, he's the special prosecutor when he suspects these things. Depending on what the law grants or does not grant him, he can proceed. But we cannot also overlook, the fact that at the same time, you don't also want to give him or her, whoever is special prosecutor, a totally free hand, right? You do want a few checks in the, as part of the process. So again, for me, fine if he wants to come out publicly and say that. Sure, he believes that he should. As I am saying, the fact that you are having a disagreement or a fundamental difference in an interpretation of how the rules should work or the process should work may not necessarily mean that someone or some person or some institution is ganged up against you. And I think that's where I part company with the with a special prosecutor, because it seems like the judiciary is intentionally undermining, his work, and that again, maybe he may know something that I don't, and I would concede that, but I just worry that this impression is being created.
All right. Is he justified? Is he justified in that suspicion when the judge who makes these adverse comments about his work and his competence and dismisses his application, and there's a subsequent application and it's going before the same judge, and he goes to the CJ and says, give me a new judge, don't give me the same judge? Is he justified in that suspicion that it appears I'm being sent to the slaughter? The same henchman, so to speak.
He's allowed to have those suspicions. I won't take that away from me. I mean, he's the one who is sitting in the hot seat of special prosecutor and knows exactly.
My question to you is that, are these suspicions reasonable from the circumstances?
From the circumstances, yes. But let me add a but though. But it doesn't mean that because the outcome didn't go your way, that those reasonable suspicions is what it is. That for me, that's my only caution.
Okay.
Right? Yes.
All right. Thank you very much. That is Professor Osai Kwapong. He is with the CDD. He's a democracy fellow with the CDD. He's a political scientist and democracy and development fellow with the CDD. He takes leave of us at this point, Dr. John Osai Kwapong. Now, to the lawyers, and Professor Bochi had started to look at those instances that the special prosecutor gave, to now give his own views of those. Yes.
Something I indicated that, just to put in context the conversation you just had with Professor Kwapong, the special prosecutor faces what I have categorized into three key difficulties or challenges. The first one is that he faces a mandate challenge. The mandate challenge is that the statute gives the special prosecutor significant powers. I was going to say wide, but I prefer significant. Significant powers, which includes freezing powers. These are prejudicial power. I mean, prejudicial, not the word prejudicial, so pre-hyphen, but pre-going to court. Prejudicial powers. In other words, powers that the special prosecutor can exercise before he goes to court. When he does exercise them, the courts are supposed to review his request on the basis of, again, the powers that have been conferred on him before coming to court. So in the case of freezing, for example, when the matter is before the court, one of the key considerations the court will have to make is whether the freezing request that has been made by the special prosecutor is necessary for the investigation. So the necessity of the freezing is material. I was not in court. I'm not privy to all the legal processes, so I can't speak to the specific case. But in the context of mandate, it just speaks to an evolving tension between the statute and the established ways of doing things in Ghana. And the established ways of doing things is you have essentially the court that exercises those powers with a certain degree of latitude of discretion. But in this case, the discretion is not really on the side of the court as much as it is on the side of the special prosecutor. And the court is supposed to review the request in the context of the necessity of the powers of the special prosecutor. I have a feeling that the mandate of the special prosecutor faces this significant challenge, but also in the context of the overall criminal procedure of Ghana. The criminal procedure of Ghana, as I indicated earlier, requires that a prosecutor establishes beyond all reasonable doubt that a crime has been committed or established. The defense only has to establish a doubt, and the fact that the doubt is reasonable. Once the defense raises this, that's it. I started by putting in context the fact that the special prosecutor, like all prosecutorial agencies in Ghana, come up against this major difficulty, and that difficulty being the fact that their capacity, particularly from a forensic investigatory standpoint, the fact that their capacity generally tends to be limited and affected, and the fact that the defense, on the other hand, rather tends to have the full benefit of, if you like, legal representation, particularly because of the persons involved. And then in addition, all they have to do is the very low bar of saying there is a doubt. The substantive cases of special prosecutor appears to be Herculean. In fact, as we speak, it doesn't appear as if he's even in the mainstream substantive one. These are collateral motions. These are motions that are designed to enable him manage the investigative process. And he's coming against this. So that's the first difficulty, the mandate one. The second difficulty, which is
the mandate one.
The mandate one, which is the statutory.
And you spoke specifically about freezing orders.
Correct.
Which he has the power to freeze people's assets and things.
Correct. Pre-court and during court.
Within a specific period, and then go to court. Now, the Section 38 of the Special Prosecutor Act says that if the special prosecutor that has reason that the property of a person or entity, when the property of a person is being investigated, I have highlighted being investigated, right, not after investigation. Then you go to 40. 40 also repeats the same. 41A says when he's satisfied that, when he goes to the court ought to satisfy itself that the respondent is being investigated, that the person you have brought before the court is being investigated. Then in 41F, it says that there are reasonable grounds to believe that a confiscation order shall be made under this act in respect of the property. All of that appear not to be when investigations have been done. A judge gives a different view. Should he not be litigating this in the court, back to the question, rather than being in the public and telling all of us that this is what the law says and the judge erred?
Correct. And that is exactly what we're dealing with. So the statute is unmistakable. And judges have given decisions lawyers have had big fights with. Now, as someone who teaches the law, I can assure you that I've been in courts and heard rulings that challenges my knowledge of the law and what I teach. In other words, the fact that I tell students to know the law in one particular way or direction, and then I hear something which makes me wonder whether, what I'm telling students, whether I can still have the confidence to tell them. So this won't be the first time, if that is what happened. It won't be the first time that a lawyer has a serious quarrel with a decision of a court. And that leads to the second difficulty that I mentioned, the perceptual difficulty. The special prosecutor faces a perceptual difficulty given the press conference.
No, you haven't answered my question. Should he be litigating this in press conferences and press releases criticizing the judge?
Right.
Or should be in the Court of Appeal going to the Supreme Court, so to speak?
I am exactly answering your question. And I know you'll probably take issue with that.
Okay.
But grant me this, you take that at the end.
All right.
But I'm exactly answering the question that the special prosecutor faces the perceptual difficulty, which feeds into the question you're asking about.
The mandate difficulty.
How he should be doing it. Exactly. Now, the perceptual difficulty is, ordinarily, when lawyers have issues with courts, What they do is simply to take advantage of the appeal processes, to take advantage of all kinds of ancillary legal processes through motions, come before courts, challenge jurisdictions, challenge substantive issues, essentially vindicate their rights. When lawyers have issues with courts, ordinarily, they are not trained to appear before the cameras and to court the court of public opinion. And that's where the perceptual difficulty comes in. Yet, the special prosecutor is not another prosecutor. He is not a regular prosecutor, and he's even less so not a regular lawyer. He is a special prosecutor with a special mandate, a public interest defender. He is someone who is working on behalf of the public with special statutory permissions and statutory allowances. One of the statutory permissions is that the special prosecutor is allowed or enabled the opportunity of appearing before the public and giving feedback. The question then is, what is the scope of the feedback that is allowed? What is the character of that feedback? What is the degree of specificity that he should give? What is the extent to which he should particularize cases? Should he limit himself to trend analysis as he sought to do, but there were particulars? The difficulty some people may have is the particularization, the fact that there were specific cases that he mentioned. But then again, his argument could be, I do not want to speak in the abstract. I do not want to just generalize and speculate. I want to be particular so people know that there are bases to what I'm saying. But the point is what I laid out earlier, that perhaps he can be given a little flack, given the fact that he doesn't have a real template that he seems to be working with. So my sense is that he was giving the public the feedback. He may appear to have gone into some specific details, and the problem with those specific details is that they may actually even sin against a cardinal legal rule, which is the fact that matters that are sub judice, you do not publicly comment on them in terms of the degree of specificity and in terms of the particularity with which you speak on them. These are difficult tensions. And the reason
so for every matter he commented on, he had already issued a press statement. And he does it the very moment the decision is made by the courts.
Right. The point I'm making is we have an evolving scenario. That evolving scenario may appear to be in tension with certain established ways of doing things, at least from the professional standpoint. But he has statutory permissions, or he has statutory allowances under the Special Prosecutors Act, the Office of the Special Prosecutors Act. Therefore, he appears to be in a peculiar terrain. As I indicated, what the law doesn't give are the extent of details, the extent of particularity, the extent of peculiarity with which he can report. And so he's given a report which appears to be going against or being in tension with professional etiquette and professional ways of doing things. But that's why I'm saying that perhaps he can be allowed the initial reports which we appear to be having at this stage, i.e. the fact that there are no real templates, and he may be evolving in the respect. I think moving forward, perhaps he may want to limit himself to trend analysis and the generalities of things.
But is there really a problem, as you suggest, that there may be a problem as to the extent to which he can go about what he tells the public on cases? Because Section 3, subsection 3, I think is unambiguous. It says he will do a half-yearly report and he will publish them in at least 2 daily newspapers of national circulation and on the website of the office. And this is what he's supposed to do, the particulars. The list of corruption cases investigated and prosecuted by the office, and the number of acquittals, convictions, and cases pending in respect of the cases prosecuted, and the value of proceeds recovered. If you go to the Section 31, Regulation 31 of the regulations, it says publicizing detected acts of corruption.
No, absolutely. Nothing you've said contradicts anything I've said. In other words, you can report. What I still maintain is the fact that the statute is still not clear on the threshold of particularities. For example, the statute says you can report on the cases, you can report on specific developments of these cases, but it doesn't speak on whether, for example, he is allowed the right of reporting on a judge's ruling on each case, even when the cases have not been completed. It's one thing to say, for example, that this case has ended and we're successful or we failed. It's another thing to say that there was a motion for X and that motion was dismissed and we disagree with the judge on that particular motion. What I indicated is that the statute is not clear on that. And given the tensions and the headwinds that are already emerging, perhaps, again, these are just, reflections on moving forward. I think, for me, in the context in which I spoke on, has to do with the fact of the perceptual difficulty. There's a danger, and I'm just saying this because there's a danger some people may create the impression that he is caught in public opinion. My impression, and I've known him as Honorable Minister has said, I've known him for a very long time. He's a very capable person. He's a very, very knowledgeable person. He is totally qualified for what he's doing. I would not for a minute question his competence. The danger is that other people may. And I think the danger is people are trying to create the impression that he's moving from the court and caught in public opinion. He's actually performing a statutory obligation, but the context of the particulars, maybe he may just want to reflect on that moving forward, the extent to which certain cases are particularized, so that people do not move away from this and create a perceptual problem. And that perceptual problem is the office may be seeking to court public opinion, when indeed more opinions are indicated he's just performing.
Thank you. Brief comments on these two. He says for a court to grant an injunction against the arrest or investigation of an individual, Charles Bissiou, the court actually issued immunity. That's literally what it is, immunity from arrest and investigation. And he was categorical that a court cannot do so.
I have to be very honest with you that I haven't really followed the detail of that, but let me take it from your report and from what you just said. I would exactly agree with him. First of all, courts do have inherent jurisdiction to do all kinds of things. So there are lots of things that are not on statute, but the High Court has inherent jurisdiction to do them in the interest of justice. One of the things that I would not foresee a court having an inherent jurisdiction to do is to grant immunity from arrest for anybody. The Constitution has been, in an inverse way, explicit by indicating that there is only one person in Ghana who is immune from arrest, the President of Ghana. The Constitution is clear. Now, the reason I'm saying this is an inverse way is because by the principles of statutory interpretation, where there's an express statement of something, there's an implied repudiation of everything else which is not stated. Yeah. So once the Constitution has mentioned that, the rest of us are subject to the investigative authorities, to the arrest and prosecutorial authorities of Ghana, and we can all be arrested and subjected to the criminal processes at any point in time.
MPs have qualified immunity.
Well, the MPs have qualified immunity, absolutely. Again, that's another one, which is very limited. But they can't be arrested. They are not immune from arrest.
Yes.
They are procedurally immune. Yeah. So it's procedural.
Depending on where they find them.
Exactly. So
what they are doing.
I'm not going to go into that because I know they fight me on that. I've said a few things about
that. It's a matter potentially for pronouncement.
I've said a few things about that, and I've lost a few MP friends. So I would say anything about the MP ones. But so clearly, as far as I'm concerned, the constitutional framework prohibits the court to give anybody immunity because the Constitution has indicated the only person who is immune from the criminal process of Ghana for the period is in office.
It doesn't matter that immunity is temporary.
No.
10 days, only 10 days.
No, because if you do that, then what you have done is that you've created, within the 10 days, you've created another class of citizen in the same bracket as the president for that 10 days. I think that would be wrong. But again, that's my opinion. I'm not a court, except that from the standpoint of pure constitutional interpretation out of court.
Then to the other one, the first case that really vexed the special prosecutor, that the man is dead, so shut up.
Again, we are all being forced into these ongoing litigation matters and all that. Again, I restrict myself to the general principles. The truth of the matter is when a lawyer has a complaint with a court, as Professor Osai mentioned, you take advantage of the appeal processes. But it is also true that sometimes decisions challenge a lawyer's perspectives or opinion before the court, before which the lawyer pleads. And so while the lawyer has the right to exercise the option of going on appeal, indeed lawyers can also express positions as far as those particular specific rulings are concerned, because those rulings are done and over and done with, subject to appeal if they are pending before any appellate body. It is clear, again, by the statute that the authority to investigate allows the special prosecutor to undertake certain things pending the investigation. So it will be surprising if indeed that was the outcome of the conclusion the court came to, because as far as I'm concerned, just as you read from the statute, his powers are pre-investigatory. And being pre-investigatory means the investigative process is ongoing. What the court can do is to question the necessity of particular acts. I will expect the court to stop actions of the special prosecutor on the grounds that they are not necessary.
Right.
They're either by reason of overbreath or by reason of a lack of indexation. They are not connected to the once the point?
There
Once they are
are
connected, once they are
portions of
necessary.
the OSP's powers and what it's supposed to do that we may even question. That is, you publish detected acts of corruption. He's detected, he should publish. Is that not prejudicial? That the law says, if you have detected acts of corruption with me, you should go ahead and publish. Is that not prejudicial?
You mean
against me?
From the statute, yes.
Yeah, that's what it says it should do.
Well, that's what I'm saying. That's what I started by saying significant powers. I told you that my earlier preference was wide powers. Wide would have been negative.
Some say that's a monster we have created.
In some ways, because what it means is that...
And I say you need a monster to fight the monster.
Well, but that can be dangerous. No, that can be dangerous. You need a monster, but the monster can have unintended victims along the line.
That's why the courts are check.
Well, but here's the problem. The balance between reputation destroyed and reputation restored often doesn't get properly achieved in the court process. When your reputation is destroyed in the line, for example, if you publish today that Kofi Abuchi has been found to have stolen 100 million cedis, and I go to court and the court says I haven't stolen 100 million cedis, Ghanaians already believe I've stolen 100 million cedis. I guarantee you, the fact that you even publish a rejoinder, blah, blah, blah. I mean, people, as far as people are concerned, these are all just, damage control, and the act has already been done. So as far as I'm concerned, when it comes to the damaging process, especially pre-investigative process, the special prosecutor should exercise some of his powers carefully.
Okay.
Because there are dangers that people's reputation can be destroyed before. But I think at this stage, we haven't seen any, there's no cause, if you ask me. I haven't seen, apart from specific major public interest cases that he's investigating, I haven't seen anything done which...
The LaBianca matter, publishing detected acts of corruption. It also says 31F, information to the public. All of these things. Yeah. And now the two GRA officials involved in the LaBianca matter, the court says, come on, you constituted yourself into a commission of inquiry or a court. There again, and Honorable Nusa, there again, the special prosecutor is not happy that the judge ignores, according to them, ignores what the law allows them to do. That he doesn't have to be a court. He doesn't have to be a commission of inquiry to be able to make adverse findings against people. The law says he should do it.
Yes. So the law says carry out a corruption risk assessment.
So people say go to appeal.
So when he has reasons to believe that Joy FM in collaboration with public officials are engaged in acts of corruption, or they are signing a contract for the performance of a service, he thinks that the contract, the way it is couched, is exposed to the risk of corruption. The special prosecutor has the power to conduct a corruption risk assessment.
They did the first one on Ejapa.
And then this one, LaBianca. The use of discretion. Whether the discretion to mark down values was proper. And was it uniform? And why were favors extended to LaBianca? You must read the report. And that is his job. Are we not interested in fighting corruption? Or is a lawyer facade? We need to understand we should get serious with fighting corruption. Now people are going to use the cause as subterfuge. You must understand that too. And to frustrate the special prosecutor, to frustrate corruption agencies. That's what we did to Yoko. That's what we did to the police. That's the perception that characterized the performance of the functions of the Attorney General. Now we are saying that we should continue on that trajectory.
The advice generally is that, yes, the law may say he should do this, but if a judge gives a different view and says you cannot do what you have done unless you are a court or you are a commission of inquiry, then it means you have a clear case where you win on appeal. Go to appeal and stop talking in the public.
So I'm not saying you shouldn't go appeal.
And suspecting that there is an attempt.
I'm inviting you, Samson. I'm inviting you and Dr. Kwapon to appreciate the light that the special prosecutor is shining onto the processes in the court. You must understand that he's not fighting the court. He's just saying that these things are happening in court. For us to understand, for you and I to understand.
You have not exhausted the processes in the court.
He doesn't need to exhaust the processes in court. He doesn't need to. He says that, look, so let me go with the first case of Cecilia Dapa. I did not agree with the special prosecutor. I thought he was wrong.
Yes, you said that.
Dead wrong. Read section 32 of the Act. It talks about seizure. When you have reasonably believe that property has been tainted, you seize to aid investigation. When you seize, you have 7 days to go to court to confirm the seizure. 7 days. And if within 60 days, you don't prefer a charge against the person from whom the property has been seized, you return the property. And when the officer who seized the property returns the property, he's immune from prosecution because you have acted in good faith. He's immune. So there are clear procedural requirements, rules, regulating that power.
He says that whilst he may not have a problem with that because he would deal with it in the court process, the judge makes comments. That you heard him clearly. He said the judge made comments suggesting that he didn't do investigations and he needed to have done investigations. And he says that's where he's dead.
So I agree. So I wrote it down. Time. So he was caught by time. And that was the argument that was made in court by the lawyers of the accused person. Or
among other things.
Among other things. Because he had 7 days. He came, he was out of time. The lawyers basically said that, well, the special prosecutor was out of time and read section 32 to him. And clearly he was out of time. But the processes are to aid investigation. You cannot say that you have not concluded investigation, so you can't come and ask me to seize. Why? Because we don't want the property to be dissipated. We don't want the property to be concealed. We don't want the property to be lost. So we want to preserve the property. Okay, so there the judge was wrong in that comment. But the time, special prosecutor was totally wrong. Reason order. Yes, and yes, the court might have wide discretions. But in this law, in section 40, we regulated the exercise of the discretion of the court. We asked the court to take certain things into consideration in determining whether to confirm the reason order. And so, clearly, special prosecutor will also have to up his game. I mean, if you are blaming the courts, if you think that the courts are not aiding your fight against corruption, you yourself have to do things right. I was not at all amused when he went in the Enim Boatin, or what was his name? The PPA.
Yes, Ejenim Eje Boatin. And
then we discovered that the assets of the Ejenim Boatin, which had been frozen, had all been lost. I was taken aback.
That was started by Amidu.
Yes.
He came to take over. And it looks like within the period, things had gone.
And then the assets were lost. So what was the purpose of the seizure? And the confirmation of the freezing orders. So I thought that they were very lax in the performance of their functions. Because the essence of that is clearly to ensure that the state doesn't get hard done by. The essence of publication of convictions, investigations, acquittals, is for us to do a value judgment of the office. Whether the office is serving the purpose for which it was created. The purpose for going on notice to confirm a seizure is to protect...
Where others go without notice.
Notice. We had said go on notice because we understood the importance of safeguarding the fundamental rights.
He could abuse those
powers. So go to court on notice for a confirmation.
Why do you think Iyoko will not abuse it, but special prosecutor will abuse it?
Because it's the office. The office is huge, it's novel, has wide powers.
And in that regard,
significant powers.
In that regard, they raise an issue.
Yes.
Iyoko goes without notice. He goes on notice.
Yes.
They say when Iyoko goes, they get a bench ruling.
Yeah.
On the spot.
Yeah.
When they go, even on notice, it takes what do you call it, a reasoned ruling, and it takes a long time.
So
In another breath, they suggest that when all of us on this bench, as lawyers, go to court and we are against the Attorney General can drag your case, not because they are the ones doing it, but the courts indulge them.
yes,
A matter that can be dealt with within 6 months. Attorney General people, in some circumstances, can hold you at ransom for a year or two.
yeah,
Not because it's the officers who are doing it, it's the courts
yes,
that sort of indulge them.
yes.
Yet he cannot get any
You
indulgence.
cannot get that.
Why?
Because you see, that is a political office as well. It's a political office as well. You don't want some lad wants to contest Boku East, Bolga East, and then a frivolous charge of corruption is brought against him. Then the case drags in court for 2 years. The person who drags the case makes sure that the primaries would have passed, and then the case is dismissed after the primaries. You would have achieved his purpose in a way. You will not have been convicted, so you are free. But you wouldn't be able to contest Bogatanga East. So that's why we put all those things in the law. And people will say that the special prosecutor, the Yoka can go to court without notice. Why do they go to court? But then you don't see the intendment of Parliament. Parliament intended to depart from the practice where you can go to court to confirm a seizure without notice. In this case, go on notice.
And you also departed from the practice where you can go and say, this case should not go on anymore, and you don't give it.
We say don't know.
As for special prosecutor,
you must give
why.
You must give reasons. So we departed from it. Because there are many cases where no legal prosecutor has been filed and then Ghanaians have raised hue and cry. And so we know. Because it's a sunshine provision.
Okay.
And so we need to shine the light on all aspects of the special prosecutor.
Right. Thank you. Thank you very much. My guests that you have been listening to so far have been the Honorable Yunusa Hussaini, lawyer, former MP, Tamale Central, and former Minister Lands and Natural Resources, Roads and Highways. He was part of those who made the special prosecutor law. In fact, during the time, it was argued that the opposition was doing more work than the party in government as far as the law was concerned, even though the law was the one single law that the President, Akufo-Addo, had been hailed to fight corruption effectively. Here in the studio also is Professor Kofi Abochi, Dean, UPSA Law School. Earlier, we spoke to Dr. John Osai-Kwapong, political scientist, democracy and development fellow, CDD Ghana. And we will take a quick break. When we return, I'll share some of your messages that you have sent in respect of this matter, and then we'll proceed to the matter of Torrentco. You've seen the Attorney General's report, sort of advice. It's a no-go. It shouldn't happen. The special prosecutor says it is also investigating that. What's going on? We'll be right back.